All right, all right, all right. Hello, everyone. Well, the one person that's watching right now. Hello, hello, hello. My name is Ayana Lugo, aka the Crafty Notary, and we are back with another book club. Today is day 11, and we are starting with chapter 16. Let me put the banner up so you know what we're reading. I got my door open because I have one of my cats here in the chair. You could see him if this wasn't in the way. Let's see if I can move it and then you can see him. Nope, still can't see him because he's black. So I got my door open. So another one of the cats had came in, but we're going to go ahead and close the door. Hopefully he doesn't go nuts and want to get out. So welcome back to the channel. Again, Ayana Lugo, Crafty Notary. Welcome to those who are here. So we are going to jump right in. We are reading the Complete How-To Guide for Notaries. This book is from the NNA. You can, you know what? Let me put my phone on Do Not Disturb because we don't want that. The book can be found at the NNA's website. By logging into your account, if you are a member, you can access the book for free digitally. If not, I'm going to share it here on the screen in just a second. And let's see, without further ado, let's make that full screen. And can I hide that? I don't think I can. I think I tried that before. So let's go ahead and add our book to the screen. There it is. All right, I'm going to make it just a tad bit larger. Ooh, not that large. There we go. That is perfect. And I'm going to put myself right here for now. So we're starting with chapter 16. We're going to be talking about troublesome documents. So these are documents that may give us some trouble. Let me hide that banner. And we will figure out how to deal with these documents. So I'm going to disappear and we will jump right in. So there are certain documents that commonly pose questions for notaries that are generally not answered by state laws and rarely are addressed by handbooks provided by notary regulating officials. Such questions can arise with any document presented for notarization that has missing or incomplete parts, is a photocopy, or bears a signature that differs from the name on the signature's identification. So, in addition to two particular document types, wills and immigration papers cause notary dilemmas. So, the first thing we're going to talk about is incomplete or blank documents. And if you look off to the side there, it explicitly states documents with unfilled blanks or that are incomplete should not be notarized. What I typically do if there's a blank field and nothing goes there, like it's not applicable, I will have the signer write NA in that field so that it cannot be filled in later on. All right. So let's see what the book says. Documents should not be notarized unless they are complete and have no blank spaces. Notarizing an incomplete or blank document is a very bad idea. In fact, laws in several states explicitly prohibit a notary from doing so, and officials in many other states discourage the practice. So common sense would prevent most notaries from notarizing the signature on a completely blank sheet of paper because a fraudulent document later could be created on the sheet above the notary certificate. Now let me stop here. Yes. And let me put my face on here so you can see me. Yes. Common sense would prevent most notaries from notarizing a signature on a completely blank sheet of paper. However, these days, common sense is not very common. And I would be willing to bet there has been a notary recently that has put their information on a completely blank sheet of paper, or one of those documents that you get in a loan package that's a general notary affidavit, I'm willing to bet someone has filled that out and stamped it, signed it, and sent it back to a title company. And you should not be doing that. All right, so let's get back to the book. Also, it would be impossible to make a journal record of a document without any features such as a title or a date. So you would think that someone would not do that. Notaries would be wise to regard the signing of a certificate on a blank or incomplete document just like the signing of a blank or incomplete bank check. In both cases, you're asking for trouble. So I don't think anybody in their right mind would sign a blank check and just send it somewhere, because it can be written for whatever the heck the other person on the other end wants to write it for. So let's talk about what makes a document complete. In order to be considered a complete document, there needs to be three elements. One, a statement by the signer. So this can be a written statement, which forms a document's text and detailed terms with which the signer has agreed. Number two, a signature. The signature indicates the signer's agreement with and willingness to be obligated by the terms of the document's text. And number three, a notary certificate. This is the wording that describes the facts the notary is requested to certify. And true story, I was doing a Ron notarization and I got a gentleman who had an application that needed to be notarized. And there was simply just a line that said notary signature and then another line that said expiration date. And I'm assuming that is my commission expiration date. Well, I explained to him that I could not sign that document or stamp it as is. And since there was no space on the document for me to attach a notarial, like the notarial language, that I would have to attach a loose certificate, and that his document would now become 2 pages. And since the application was for a city, a government, a city municipality, I guess I say it that way, it was for the city. He wasn't certain that they would accept his document as 2 with the loose certificate and the notarization on the second page. So I recommended, now I'm in the state of Florida again, and he was not in the state of Florida. He was in the state of Georgia. And so since I don't know Georgia's laws in and out like I do Florida's laws, for the most part, I suggested that he get in contact with the Georgia notary to find out what they are required to have on the document in order to notarize it, because they may have different requirements than what Florida has. Remember, Florida has 9 requirements that must be on each and every document, notary certificate, in order to be valid. And so if I can't put those 9 things on that piece of paper, I'm going to attach a loose certificate. And if I can't attach a loose certificate, then I'm not signing. So he went on his way. He wasn't salty or mad or anything like that. He just went on his way. And hopefully he found an answer to what his question, to his problem, I guess. Even if that meant he could just contact the city and ask them if they would accept the document with the loose certificate. So you want to make sure that you have those 3 things because they are very important. And I have seen documents come through where there's no signature required on the document. And I'm like, well, what do I notarize if you don't have a signature there? All right. So documents that are complete except for blank spaces that will be filled in later also have great potential for fraudulent misuse. A borrower, for example, might sign an incomplete promissory note, trusting that the lender will fill it out, and then find out later that the lender has written in twice the amount actually borrowed or twice the agreed interest rate. Incomplete spaces are a danger for the document signer, who may be victimized, and for the notary, who may be required to testify in a subsequent lawsuit. Ironically, the signer, who is the potential victim, often insists that an incomplete document be notarized. It may be inconvenient to obtain data to complete the document, and the signer may decide to get the notarization out of the way first. But the prudent notary will decline to notarize an incomplete document and instead will ask any signer to fill in the blank spaces of the document before notarizing. If the spaces are inapplicable and intended to be left blank, the signer should line through each space in ink or write not applicable or NA in the blank. The notary may not, however, tell the signer what to put in the blanks. If the signer is unsure what to put, he or she should contact the document's issuer, its eventual recipient, or an attorney. Okay, so we shouldn't be out here telling people what to put in the space. We shouldn't be authorizing them to put in NA. But if it is not applicable, and I would just say that if it's not applicable, you may put that. But if they don't know, you can't tell them what to put there. All right, so in rare occasions or situations, there may be an acceptable reason for leaving a space blank on a notarized document. Sometimes, for example, a paper requiring more than one signature must be circulated to collect the separate signatures and the notary certificates. Such a document's date of signing space may be left blank until the final signature is affixed. On such occasion, a notary should record in the journal the reason the space was left blank. In addition, to preserve confidentiality in adoptions, it is generally acceptable for the names of birth mothers or adopted parents to be filled in after certain adoption forms are signed and notarized. A recordable document should not be regarded as incomplete just because the box labeled reserved for use by recorder has not been filled out. This information can only be completed after the notarized paper has been recorded. Also, large recordable parcel maps may include several separate documents on the same sheet of paper, such as a statement by purchaser or a statement by surveyor. These may be signed and notarized separately, even though other documents or statements printed on the same sheet have not been completed. All right, so let's next talk about photographs, birth certificates, checks, and artistic works. So signers sometimes request notarization of papers that do not have all of the three necessary elements. For example, notaries at times are asked to notarize a photograph in order to identify the person in the picture. However, a photograph by itself does not have a signer's personal statement, a signature, or a notary certificate and should not be notarized. All right. So some individuals sign a copy of their birth certificate and request notarization in an attempt to prove U.S. citizenship. However, such a document should not be notarized because two elements, the personal statement and the notary certificate, are missing. This is also true of signatures on the back of bank checks and or on paintings. Sometimes persons will try to protect their rights to inventions or artistic works such as songs and plays by asking a notary to sign, seal, and date their design plan or actual creations. In these cases, all three necessary elements may be missing. A notary's signature and seal without jurat, acknowledgement, or other appropriate wording do not constitute a certificate. Persons wishing to protect their ownership of an invention should contact a patent attorney or the U.S. Patent and Trademark Office in Washington, D.C. Similarly, those who want to protect their right of authorship to a literary work should contact a copyright attorney or the U.S. Copyright Office in Washington, D.C. So we cannot notarize people's works in an attempt to make them feel like it's copyrighted or patented or anything like that. So a photocopy or a fax may be notarized if its signature is original and not itself photocopied. That is, the signer must have signed the photocopy or fax with a pen and ink. So let me read that again. A photocopy or a fax copy may be notarized if its signature is original and not itself photocopied. So they can copy the document and then sign it. A photocopy or a fax copy of a signature may never be notarized. However, public recorders sometimes will not accept notarized photocopies because they will not adequately reproduce in microfilming. Some fax documents may fade. Since some fax documents may fade, it is suggested that they be photocopied and then the photocopy is signed and notarized. Okay? And that was when fax documents, I don't know, came out with the thermal ink, but nowadays I don't think faxed copies will fade any more than a laser jet printed copy. So that may be like an old school fax machine. Nowadays, faxes are e-fax, and you can have the documents printed out just on your regular printer. So, all right. So on the side, it says photocopies may be notarized so long as the signature is original and not a copy. All right, let's talk about wills. So wills are such sensitive and important documents that there are certain dangers for notaries who execute them. Some handwritten wills may be invalidated by notarization. Notaries who make the mistake of helping prepare a will may be sued by would-be or dissatisfied heirs. And that is because you will be practicing unauthorized practice of law. So you have to be careful that we are not preparing any documents. A document presented to a notary as a will should be notarized only if clear instructions and a certificate are provided for the notary. Ideally, the signer should be following the precise directions of an attorney. Often, misguided individuals will prepare their own wills and bring them to the notary to have them legalized. They will depend on the notaries to know what kind of notarization is appropriate. And of course, notaries have no authority to offer such advice. Whether notarized or not, these supposed wills may be worthless. In many states, notarization of a will is rarely done and is unnecessary if other witnessing procedures are used. In some states, wills don't need to be notarized at all. Often, it is not the signature of the testator or testatrix, who is the maker of the will, that must be notarized, but the signatures of the witnesses on affidavits appended to the will. So I'll just say for sure, in the state of Florida, wills should be notarized, and there should be witnesses to the will. I forgot what I was going to say. Hi, Rachel. That's why I was forgetting what I was going to say. Hi, Rachel. So in the state of Florida, wills are notarized, and a self-proving will have the signer signature notarized and the witnesses signatures notarized as well. All right. So I guess in some states it's not required. However, this statement here, whether notarized or not, the wills can be worthless, still holds true even in the state of Florida. So you have to be careful that you know what you're doing when you are notarizing a will. You need to make sure that you're following the law of your state or the state of Florida to a T as it relates to a will or any other estate planning documents, because the fact of the matter is you won't know if that will is worthless until the person's gone. So that is a crappy time to find out whether or not a will actually worked. So you have to be careful. You have to be careful to ensure that you've done it properly. All right. Documents popularly called living wills may be notarized without special attention required by wills. That's because living wills are not actually wills, but they're written statements of a signer's wishes concerning medical treatment in the event a signer has an illness or injury and is unable to give instructions on his or her own behalf. All right, so that is what a living will is. And now let's talk about immigration documents. Many notaries are reluctant to notarize documents issued by or filed with the U.S. Citizenship and Immigration Services due to concern about the severe penalties for photocopying naturalization certificates and a few other critical USCIS forms. This reluctance is unfounded. However, there are no laws that prohibit the notarization of immigration documents. The most common USCIS forms that notary may be requested to notarize are the affidavit of support and certain other non-standard documents such as translators' declarations that may be submitted in support of the USCIS petitions. All may be notarized. Another commonly seen USCIS document that must be notarized is the form needed for the pre-approval of an orphan visa. The National Notary Association recommends that only experienced notaries who customarily work with agencies specializing with international adoptions notarize these forms, because a missing or incomplete document in the adoption dossier can jeopardize the entire adoption. In addition, this form does not include notarial wording, so the signer, adoption agency, or attorney must provide wording or instruct the notary as to what type of notarization, acknowledgement, or jurat to perform. Signers asking the notary questions should be directed to their adoption agency or attorney for answers. Okay, now let's talk about name and identification discrepancies. Notaries occasionally are asked to notarize a document bearing a name that differs from the name on the signer's current ID. This is not unusual. People commonly change their names legally due to divorce, marriage, or other reasons, and some use casual or formal variations of their names for different circumstances. For example, the driver's license presented to the notary may say Sandra A. Williams, the signer's current married name, but the document requires her to sign as Sandra A. Buchanan, which is her maiden name. Or the notary or credible identifying witnesses may personally know the signer as Gail McGuire, the name she commonly used, but the document calls for a signature of Patricia Gail McGuire, which is her full legal name. To prevent invalidation or rejection of a document, a notary must pay particular attention to the name that is being notarized. While a signer may be directed by an escrow or a title company to sign a former name on a real estate document, the notary must be able to identify the signer by the name that is on the document. This is the notary's challenge with discrepancies between the name on the document and the name on the ID. In cases where the document name and ID do not agree, to perform the notarization, the notary must either 1. Determine if the difference is acceptable. 2. Have the signer provide additional identification. Or 3. Have the signer sign with AKA, also known as. Now, if none of these 3 solutions can be met or is satisfactory, then the notary has no choice but to refuse to perform the notary act. So I'm going to stop there for a minute because I want to reiterate this particular section here. So the 3 options are an either or. So all 3 do not have to be met. It is one of them. So if you determine that the difference in names is acceptable, then you can proceed. So that's subjective. It's up to you as the notary. Number 2, if they have additional ID with their married name, then you're good to go. They can produce that ID or whatever they have, and you can move forward with the notarization. And then number 3, if you feel comfortable, and this is just me saying this is not what the book says, but if you feel comfortable that the different name is the signer and one and the same as the name on the document, you can have the signer sign the name on the document with AKA, also known as the name on the ID, or vice versa. Okay. So that part is a little bit subjective, and you have to be careful when proceeding or moving forward to make sure that you feel comfortable enough to proceed with the notarization. And of course, you want to document all of that in your journal, in the notes. So any discrepancies you want to document, because in the event that should come back to you in the form of a lawsuit or a subpoena, you want to be able to remember what you did or what you were thinking, your rationale was behind proceeding with that notarization. All right. So let's talk about some acceptable differences. So the name on the document over here on the side, the name on the document may be shorter than the name on the ID, but it can't be longer. So it can be less, but it can be more. So some names discrepancies are acceptable for the purposes of notarization, but the notary must not allow the signer to take excessive liberties with the differences. When the name on the document and the ID differ, the notary should first apply the test outlined in Chapter 4. In addition, the names may not be substantially different. For example, the ID name reads John David Hunt. The notary would be able to notarize certain abbreviated forms of that name, such as John D. Hunt, J.D. Hunt, and John Hunt, right? Because it's less than John David Hunt. It's not more, but it is less. Following examples of acceptable and unacceptable document ID name differences. So here's some acceptable ones. You got Kevin J. White, and the name on the ID is Kevin James White. So Kevin J, the J is less than the James, so you can proceed. You got M.E. Cole, and on the ID, it's Marissa Ellen Cole. So you can move forward with that. You got Pat Johnson, and then on the ID, you got Patricia Johnson. So that is less and not more, so you can proceed. But here are some unacceptable differences. You got Jane K. Douglas Smith, but our ID says Jane K. Douglas. Smith has been added. That is more than what's on the ID, so you cannot move forward. Byron John Burns III. Adding the third creates more than Byron John Burns, because knowing that you have a third, whereas he may be the second, or he may be the junior, or he may be the senior. You don't know that. Could be the fifth. You got Cynthia Ann Green, and on the ID it's Cynthia Ann Summers. So that's just a blatant name change. It's not the same at all. And then you got Charlie Kim, and on the ID you got Chan Ho Kim. And again, Charlie Kim is nothing like Chan Ho, and there's no way you can get Charlie from Chan Ho. And so even though maybe in their country Charlie is short for Chan, Chan Ho, but you cannot use that to move forward, and it's unacceptable. So it is not unheard of for unscrupulous persons to exploit name similarities to steal valuable property. The victim sometimes will be the exploiter's similarly named parent, son, or daughter. So suffixes such as the third and junior should not be ignored. The safest policy for the notary is to insert on the notarial certificate the exact full name appearing on the ID. Okay, not the document, but the ID. If the name differences are too substantial, the next step is for the notary to ask for some form of alternate identification to verify the name as required by the document, or to have the person sign using AKA or also known as. Because when you ask them to sign AKA, also known as their name on the ID or the name on the document, well, the name on the ID, they're putting their name that's on their ID on the document. So if they're acting in a fraudulent manner, they may not want to put their full name, their full government name on the document. All right. So, hey, Reg, no problem. Let's talk about additional identification. So in some cases, the signer may be able to provide some other form of additional acceptable identification that agrees with the name as it appears on the document. So for example, if the signer's driver's license name is different from the name on the document, perhaps credible identifying witnesses might know and be able to identify the signer by the document name. Or maybe the signer's passport has the same name as the document, while their most recent driver's license does not. So yeah, if they can bring more ID with the other name on there, more power to them. We can roll with that. All right. Also known as, or AKA. Another possible solution for document and ID name discrepancies is for the signer to sign both names, linking the two with the phrase also known as, or AKA, or other wording to that effect. First, the signer signs the document using the name as it appears on the ID. Next, you write AKA and then sign the name as required on the document. The notary notarizes only the name that appears on the ID, and this is the only name that appears on the notarial certificate, since this name is the only one which can be proven to the notary. Typically, the signature format would be, so you got Beverly C. Peterson, where maybe her maiden name is Eisman, so you have also known as Beverly C. Eisman. Now, I will say, if you are doing a loan signing and you run into this issue, before you make the call to have them sign using the AKA, and before you get to signing the documents at all, because the very first thing you do at a loan signing is check the ID against the name on the documents. If the names don't match and they don't have any other piece of ID or evidence that shows the former name or the other name, you should contact them immediately and let them know that before you proceed with signing, having them do an AKA, because those documents might not be valid. And so instead of wasting your time, contact the loan signing, the signing service or the title company or the lender and get clarification on how they would like for you to proceed. However, do not let them tell you how the person should sign. So if they're telling you the person should just go ahead and sign with that name that you don't have ID for, that is unacceptable, and you need to stand your ground on that particular fact. However, you can offer or throw out that you can have them sign as the ID version, and then the AKA, the name on the document. And if that's satisfactory to them, then you can proceed. So, but you will want to link them in before you move forward and waste your time. That's just a little sidebar. All right, so here's the alternate. Beverly C. Patterson, AKA Beverly C. Eisman, or Peterson. Patterson was a lady that lived near my grandmother, Beverly Patterson, when it wasn't Beverly C. Patterson. That's hilarious. Or here is the alternate, another alternate, Beverly C. Peterson, who took title to property in the name of Beverly C. Eisman. And like I said, you would want to make sure if you're doing a loan signing that you get this clarified before you use any of these. Now, if you're just If you're notarizing independent documents for a customer and not another business, not a signing service or a title company, then they should be clear. If that comes up and they don't have ID, they should verify with the party on the other end that it would be acceptable for them to sign in this manner. And that's just providing good customer service. All right. So a similar procedure can be used when a signer wants to use a professional name in addition to the real name. So here the phrase is professionally known as, or PKA, and that would replace AKA. So when two names are signed, it is critical that the notary only print the ID name in the space on a notarial certificate. So personally appear before me, name, who acknowledged. That is the name on the ID. We are always only ever using the name on the ID on the notary certificate. And that is because that's the only name we can verify through identifying documents. So if they can identify themselves as the other name, then we can put that name on the notarial certificate. Unless a signer is personally known to the notary by both names, it is the signer who must link the two names when signing the documents, not the notary when completing the certificate. Also, the notary cannot advise the signer to use AKA or a similar procedure. That choice must be the signer. So there you go. Maybe throw out everything I just said before that. So we cannot advise them to sign that way, but we can tell them that they have the option. We can't tell them that's the way they should sign, but it is an option for them to sign that way. And again, that choice definitely has to be the signers, the lenders. It has to be up to the signer at the end of the day. However, the people who are accepting the documents also need to know that they will accept it in that manner. All right. In general, signers can write any other name or title, like treasurer, vice president, they want after their signature, but the notary certificate must bear only documented names and titles that appear on the signer's ID. So here's an important check. The signer should check with the documents, I just said that, receiving agency to make sure that the use of AKA or PKA is acceptable. Some agencies may not accept the documents signed in this manner. If not, the only option to the signer are either to locate a notary who can identify the signer in the required name through personal knowledge, or bring a credible identifying witness to the notary to verify the name. All right. So there we go. That is chapter 16. That was chapter 16. And let me go back here. And let me see how big chapter 17 is. Because your girl's a little bit tired. Nope, we're going to go ahead and do this one. So, sweet. All right, let's go ahead to chapter 17. There we go. So now we're going to be talking about, let me make this full screen, accommodating the recorder. So recorder is the county clerk, the recorder. Okay. So over here, since notarization is necessary to record a document in the public record, the notary and signer must be concerned with the requirements of the recording official, or the document may be rejected. So, all right, let me go away. There we go. Notarization isn't it? Hold on. Let me make it bigger. I thought it needed to be bigger. There we go. Notarization is an important step leading to the public recording of deeds and other valuable documents. When such papers are placed in the public record, the rights of private individuals, particularly in regard to ownership of real property, are safeguarded. In notarizing documents and in performing certain other statutory duties, notaries often have to adapt to the requirements of public recording officials. Usually, Recording documents is the responsibility of a county official called a recorder, registrar, or auditor. In Florida, we call them the clerk of courts, I think we call them here. Like in Michigan, they call it the Secretary of State, I believe, is the recorder, the recording entity. But I think in Florida, it is the clerk of courts or the county clerk, something like that. Like the notary, a recorder is a ministerial officer who must follow written rules closely. These rules dictate the type and format of documents that may be recorded and may vary from state to state and county to county. So, a recorder cannot accept deeds or certain other signed documents unless they have been acknowledged before a notary or other official with notary powers first. The recorder relies on the notary to verify that a document's signature is genuine. If the notary does not properly complete the notarization, or if there are significant discrepancies, the recorder has no choice but to reject the filing of the document. 4 problems commonly cause recorders to reject notarized documents: an improper seal impression, an improper signature, an improper notary certificate, and improperly made corrections. All right, let's talk about improper seal impression. So, missing, illegible or unreadable, overprinted, and expired notary seals are the most frequent cause of document rejection. Even a legible seal impression can be unacceptable if it's stamped over wording. Sidebar: you should never be stamping over any wording, ever. Notaries never should touch up an illegible impression with a pen and ink, as this is certain cause for rejection by many recorders. If a seal impression is unreadable, another impression that is readable should be affixed nearby. When there is no room for another impression, a certificate form may have to be attached. I have had times where my notary stamp did not stamp properly. And I have this issue more often with my mini stamp, which has now been retired to the glove compartment in my car. And that is because a lot of times it's so small that it doesn't stamp completely and the words are illegible. So oftentimes I would draw a line through the bad stamp, initial it and date it, and then stamp again. So now that I know that that is an issue, I just don't use that stamp very often anymore. I purchased another mini stamp that's like a travel stamp. It's over there, so I can't get it. But it works a lot better than that mini stamp that I have. Next, we're going to talk about improper signature. A missing signature of the notary or document signer is a common cause for document rejection, as is a signature that differs from the notary's name in the seal or from the notary's name in the document text or certificate. Sometimes a person with a new name will be required to sign a deed or other property conveyance paper in a former name. As discussed in the previous chapter, one possible solution for such signers is to find a notary or credible identifying witnesses who personally know them by both names. Another solution allowed by recorders in some states is for the notary to write the signer's present new name, the one the notary can identify, on the certificate, while the signer signs this present name on the document and adds after the signature, also known as the former name, or who took title as the former name. The next one is improper notary certificate. So, notary certificate wording that is not appropriate for the particular act or that does not comply with state requirements is another cause for document rejection. If the wording included on the document is not appropriate or does not comply with state law, the notary may be asked to correct the wording or attach a certificate form containing the correct wording. Inappropriate or improperly completed notary certificates often prompt recorders to reject documents. When, for example, a person has signed a deed or as a corporate officer, the deed will not be accepted for recording if it bears an acknowledgement certificate for an individual. Notary certificates with dates preceding the document's date of signing also may cause rejection of a document, as may changes to a certificate not initialed by the notary or in writing different from the notaries. So I wanted to go back to the corporate officer. There are acknowledgement certificates for authorized representatives. So you need to make sure that if someone is signing in an authorized capacity, such as a corporate officer, that you have the certificate, the proper certificate for a authorized representative. All right. Improper corrections is next. Improperly made corrections on the document or notary certificate frequently cause rejection of a document. In general, correction fluid, aka whiteout, non-transparent tape, or any material that will cover up wording should not be used on a recordable document or its notary certificate, since recorders may be suspicious about what was covered up. Whenever a notary corrects any wording on a certificate, such as the wrong venue, or a signer corrects any wording in the document, the following steps should be taken in dark ink. Line or type through the incorrect wording. So that could be typing X's or a line. Print or type the correct wording above the line out and initial and date the correction. If excessive corrections or changes are necessary on a certificate, the notary should just consider starting over with a brand new certificate. All right, so now let's talk about authentication. Authentication is when the notary's authority is being proven. In the state of Florida, authentication can only come from Tallahassee, from the division of, I think, business or something or another. But it's the state of Florida, the secretaries of the state of Florida, I believe it is what it is, or the governor's office of the state of Florida. I can't think of the name, but it is the office in Tallahassee. No, we're talking about authentication, which is different than an apostille. So when a notarized document is sent out of the country or state, out of the state or out of the country, the recipient may require proof that the notary's signature and seal are genuine. This verification of the genuineness of the signature and seal of a notary is called authentication or legalization. The customary proof is a certificate of authority, which is also called a certificate of capacity, a certificate of prothonotary, or a flag. That's a crazy word. It is issued and attached to the notarized document by the local or state official with custody of notary bonds and oaths. This certificate states that the signature and seal on the document to which it is attached belong to a legitimate notary. Anyone wanting proof that a particular individual holds a notary commission may request a certificate of authority from the official with custody of notary bonds and oaths. So like I said, in the state of Florida, this will come from Tallahassee. All right. And one example of this is Puerto Rico. And Puerto Rico is a U.S. territory, it's a U.S. territory. However, when someone from the mainland notarizes a document, oftentimes the recipient on the other end in Puerto Rico requests an authentication to confirm that the notary is authentic, that the notary is legal, that they are commissioned, and that they have the authority to provide a notarization. So that's authentication. Documents sent to another state. Normally, for a document recipient elsewhere in the United States or territories, a single certificate of authority from a county clerk or proto-notary or designated local official is sufficient enough to prove sufficient proof of a notary's authority. Obtaining a certificate of authority is a responsibility of the signer or the document recipient and not the notary. However, notaries may have to direct signers to the certificate issuing offices where their bonds and oaths are filed. Usually, anyone bearing a notarized document and paying the required fee can have a certificate of authority attached to a document. Sometimes this procedure may be carried out by mail. And then it just talks about the varying state laws. So, for a notarized document sent abroad, the authentication procedure may be quite complicated and time consuming. It can involve attachment of as many as 5 or 6 separate certificates of authority, typically starting with the clerk of the notary's county and continuing in succession to the Secretary of State, the U.S. Secretary of the State, the particular foreign consulate in D.C., and finally to a ministry in the foreign nation. Each certificate validates the authenticity of the preceding one. As can be imagined, this traditional process of chain certification often takes months. Many nations have devised shortcuts. So, for instance, in some American cities, foreign consulates may ask nearby notaries for examples of their seal and signatures. The consulates may then refer the signers of foreign-bound documents to these notaries and, through the samples, authenticate the notarizations themselves, shortening the time of going through U.S. officials. All right, and it is important to note that frequently notary certificates on documents notarized in the United States and sent abroad have been drafted in compliance with foreign notary laws. Notaries should ensure that their state laws authorize them to perform acts in those certificates. Now we'll talk about apostille. More than 90 nations, including the United States, participate in a treaty that streamlines authentication of notarized documents sent between any two of the participating nations. Called the Hague Convention Abolishing the Requirement of Legalization for Foreign Public Documents, this treaty permits one-step authentication through the use of a standard certificate of authority called an apostille. It is French for notation. Some people call them apostles. Some people call them apostles. The French word is apostille. So that is what I tried to say. Designated state officials, the Secretary of State in most cases, are authorized to attach an apostille to foreign-bound notarized document as the only needed proof of valid notary commission. The attached apostille, which usually may be obtained through mail, will be honored in any of the other nations subscribing to the Hague Convention. As with authentication, procedures for obtaining apostilles vary from state to state. The Office of the Notary Regulating Official for the notary's state or reference, such as U.S. Notary Reference Manual, which is published by the National Notary Association, should be consulted for instructions. So for more information, you can see a list of countries, visit the convention's website, and the website address is there. So I do want to say, as it relates to apostilles, that many states will have either the option to get an authentication or an apostille. In the state of Florida, typically it is simply called an apostille. because it is validating the proof of the notary commission. Or it is validating the certified copies. So remember, we can't notarize copies like birth certificates, divorce certificate, decrees, marriage licenses, any public records we can't notarize. However, sometimes the foreign country may want that document to be authenticated. And so that is when you will request an apostille from the state of Florida, or authentication from whatever other state that you may be facilitating this service in. You do not have to be a notary in order to service someone in obtaining an apostille. You do need to be a notary in order to notarize their documents. So if they need a stamp, then you have to be a notary for that. But in order to facilitate them receiving the apostille, you can either direct them where to go, or you can complete it on their behalf. And many people do that, and there is nothing wrong with that. Even when you have to go out of state. So what you want to pay attention to is what state the document is from. Because if there is someone here in Florida, but they were born in New York, and their document is originating from New York, it cannot be authenticated or apostilled here in Florida. It has to be apostilled or authenticated in the state where they were from. So that is what I wanted to add to that. And we are at the end of that particular chapter. So we are going to stop here because I want to eat dinner. And we will pick back up next Thursday with common pitfalls, starting with detecting fraudulent identification. And my hope is that we can get through all three of those chapters, 18, 19, and 20, in one day. So that way, that leaves possibly 1 to 2 Thursdays left for this particular book club. And the jury is out on whether or not I will do another book. But what I do want to do, or what I would like to do, is start doing live Q&As. So for everyone watching, I want to start doing live Q&As once a week. And I'm going to do it with some of my notary friends and guests so that we can get questions answered. All right. So that is it for today. Please like this video on your way out. So if you close the chat, the live chat, and hit the like button, I would greatly appreciate that. It helps the algorithm. And make sure to subscribe to the channel. And make sure to comment below if you have any questions. I do answer each and every comment on all of my videos. So if you go back and watch any of my videos, I do answer questions. So until the next time, you are so welcome, Jennifer. Thank you for showing up. Oh, is it Thanksgiving next week? Hold on. My moderator, Reggie, is on the scene. Let's see. Oh, okay. So we got next week is the 17th. The following week is the 24th. So we could possibly be done next week, December 1st or December 8th, in which I'm doing my Ron class in December. There he is. Now you can see him over there. He woke up. There he is. That's Apollo. Say hi, Apollo. He's looking at Mama on the screen. Like, Mama, why are you up there? So, yeah, I know that's 24th. So we will skip the 24th. So November 24th is a Thursday. We will not have book club on that day. But I'm hoping that on the 17th, we can get through 18, 19, and 20, and then come back on December 1st and do 21, 22, and then December 8th do 23, 24, and then we'll be done. All right. So that is all I have for today. Thank you, Dee. Thank you so much for attending. And I will see you guys next Thursday. Peace out.